Hello, thank you for joining me. Today we're talking about the infamous D&E grounds. These are the grounds that you'll see in just about every petition. They are the abuse and neglect grounds is how they're referred to sometimes. One of the things about the D&E grounds is that if your client is the child that they removed, or is the parent that they removed the child from, then odds are they already have D&E grounds because they kind of have to prove that to be able to remove the child in the first place. Now, one important difference is the burden of proof. It's pretty low at an adversary hearing, or relatively low, I should say, where it's relatively high at a final hearing. So there could be some discrepancy there. So you always want to look for that. Of course, if you're representing the non-offending parent, or a non-offending parent, as there can be more than two parents in a case, then you want to look at this, and it may not apply to your clients, but it still could, and we'll talk about some why. So I'm going to read through D&E real quickly here, just so we've got that out. And actually, I'll put it up here, probably put it up here on the screen. But D is knowingly placed or knowingly allowed the child to remain in conditions or surroundings which endanger the physical or emotional well-being of the child. So it has a knowingly component. The parent has to have knowingly placed them there and knowingly kept them in conditions. And these conditions have to endanger the physical or emotional well-being of the child. Now, E says engaged in conduct or knowingly place the child with persons who engage in conduct which endangers the physical or emotional well-being of the child. Now, notice that this talks about conduct specifically. So the difference between the two is, at least in theory, we're talking about the surroundings of the child, the conditions, whereas we're talking about parental conduct. But even look at E, place the child with persons who engage in conduct which endangers. Well, that seems to be, that would apply to D as well, because you place them in surroundings that would endanger them. My point being that there is a lot of overlap between D and E. In fact, there's probably a lot more behavior and things that will apply to both than just one or the other. Some common issues that come up in this that have been addressed with the courts. First of all, the risk of danger is enough. The child doesn't have to actually be injured. So, now we're discussing, is there a risk and how much of a risk? Abuse of one child can be used to show danger to another child, even if the other child, the one in your case, was not even born before the abuse occurred. Now, that doesn't mean that that automatically shows abuse. It can. You're going to have to look at the totality of the circumstances. How bad was the abuse? How strong was the evidence? How long ago was it? What have the parents done since then? Is this something that happened when a parent was 19 and now they're 35 with 4 children and there's an issue with one of them? Well, if they've been raising 3 children with no issues, then that might give you a strong argument that, hey, this is not the same person. But remember that a lot of this just adds up. That's what they're trying to do, is add up enough stuff to show a danger. The endangering conduct does not have to be aimed at the child. For example, one thing that often comes up is domestic violence, and domestic violence in the presence of the child. Well, obviously the violence is not aimed at the child, but it can have a devastating emotional effect and actually put them in danger of physical injury, because when couples are fighting, or a lot of times there's collateral damage. If there's other people around, the child could get injured. Course of conduct is a term that's used a lot in the courts and that the department's attorney will focus on, meaning that if you have engaged in behavior or a lifestyle that puts the child in danger over time. So if your client has been in and out of prison for the last 20 years, especially for violent charges and things like that, but regardless, that puts a child at risk of abandonment, of the parent being in and out of prison. If it's for drug use, constant drug use, that can show endangerment to the child. Now again, none of these do that automatically. They have to show how it endangers the child. And that's where your argument comes in, is how it doesn't. So again, if they're going to jail and every time they do, the child is taken care of by a family member, you can show that there's no danger to the child. If the reasons they're going to jail are not violent or something that could directly affect the child, then you have an argument on that. Now, obviously, the longer the history of their drug use and criminal activity, the worse it is. But as we'll talk about in a second, incarceration by itself is not enough. Drug use by itself is not enough. That course of conduct is where they'll where CPS will get their case. That's where they will win their trial, is by showing a course of conduct. Fort Worth Court of Appeals has noted that a parent's criminal background is particularly relevant if it demonstrates a tendency towards violence, especially violence against family members. So again, what is your client's background? And if they have a long history of beating up girlfriends and wives or things like that, then that's obviously going to hurt their case. Again, how long has it been? Has he been rehabilitated? What's gone on? You need to look at all those things. Don't assume any of these mean that you've lost. Actions before and after birth are relevant. That's sometimes people argue, hey, I did all that before my child was born. Well, so what? It's an indication of who you are and what you're capable of. You need to follow that up with, look, that was long before my child was born, and I have done this, that, and the other thing. So you need to show what the client has done to change their behavior, change their lifestyle, whatever it is, to show that those things in the past are not reflective of how they are today. At least one court has said that domestic violence outside the child's presence can be endangerment. Again, just because it can be doesn't mean it is. These cases tend to be fact specific. Is drug use alone enough? Well, the 14th, 8th, and 7th Courts of Appeals seem to think not. Whereas the 1st, 3rd, and 9th courts agree or believe that it can be enough. So you really got to look at this. And the point is, the fact that they've used drugs should not be enough. The fact that they're continuing to use drugs, maybe that should be enough. Obviously, the courts don't agree, so I'm sure that lots of people disagree on that. The types of drugs, behavior beyond the drugs, that's the thing that's going to help or hurt your case. So, are they still using drugs during the case? That's always going to be damaging to your case. Obviously, that's not a surprise. Have they stopped using? Are they smoking marijuana because they've got a condition and it helps with the pain? I don't know if that's true or not. It's fairly accepted, at least in some areas. Judges are going to feel different about that. But obviously, that's not as serious as someone that is using a lot of methamphetamines on a daily or every other day basis or something. Those are where your arguments come in. Basically, those courts that don't think it's enough, they just say you've got that the state has to show that causal connection. So you need to show that there is no causal connection, or show that they have not shown a causal connection between the drug use and endangering the child. Is it your clients want to try acid and they leave the children with the grandparents and they go someplace where they can spend a weekend trying acid, and then after that they come back and that's the only time they use it? Well, you're going to have a tough time finding a causal connection, because they put their child in a safe place while they engaged in that behavior. There may still be some concerns, and as we know, most people that use drugs don't do it that way. But I have seen at least one case where at least the parents claimed that that's what they did, and maybe they did. But again, using drugs during the case is different. If they're using drugs during the case, that's worse, because the courts are going to ask themselves, I think, and most jurors, if this is how they're behaving while they're living in a fishbowl with everybody watching, what's it going to be like when nobody's around? And that's why using drugs during the case is obviously always going to be bad for the case. Again, incarceration by itself is not enough. If the father was unaware of the pregnancy when committing the crime, then it may not apply. That's something that one court has even said. There's been a case where they overturned the termination of father's rights. He was in prison, but he arranged with a family member to have the child cared for. He even provided money from his commissary fund, or whatever they call it, to help with the child. Engaged, to the extent that he could. It's the only time I actually haven't seen that. That's the only time I've heard of it. But in that case, they said, look, the incarceration by itself is not enough. There are some exceptions to that, and we'll talk about that. There's another ground that talks about incarceration, but there's some elements involved, and I'll talk about that in another video. But when you're under here, they were talking about whether it's endangerment or not, and not by itself. You have to show something else with it. Now, what he's incarcerated for, now that could all be enough. But so at least one court has said that the service plan is relevant to E ground. And this goes back to the course of conduct. The course of conduct runs before the case ever started or the child was born, all the way through the case. The failure to engage in services and the failure to address the issues that brought the child into care, that's going to be relevant to endangerment. Mental illness and endangerment. There is a mental illness ground, and I'll talk about that in another video. But can you terminate based on the D&E grounds for mental illness? Well, as is always the case, the answer is it depends. Parents who refuse to get treatment for their mental illness, courts have said that exposes the child to danger. The parent has chosen not to address the issue. Now, of course, there's all sorts of things you could call mental illness. You have to show that the mental illness is causing endangerment, is causing a danger to the child, either the surroundings or, so we're not talking about, a little depression or something like that. There has to be that connection. If there's not, they probably wouldn't have come to CPS's attention in the first place. But they do have to show that it's relating to the child. And some parents just don't, or some people don't want to deal with it. They don't like the medicine. They don't want to go through the therapy, whatever it is they need. And the courts have said that can be a factor for the court to consider. Again, it's not automatic. It's a factor for the court or the jury to consider. Some other things that have been found to be endangerment: inadequate nutrition, failure to thrive, that's one that comes up. And one-time drug use is not automatically enough. So just because somebody used drugs once, that by itself is not automatically enough. You're going to have something more. Is the drug use tied to something? The D&E grounds are usually not hard for the department to prove against the offending parent. However, remember, proving a ground is not enough. That's just one step. You don't even get to best interest unless they can prove the ground. Well, thank you for watching today, and I hope you found it helpful. I'll see you next time.